Major breaking news. The United States Supreme Court has just ruled against Planned Parenthood in a Medicaid case. But what's critically important is the language the Supreme Court just used is going to show that the anti-gun movement's strategy over the last several years is going to backfire big time on them, which bodes really good news for our right to keep and bear arms. Stay tuned. We're going to make you the smartest person in the room, connect some dots, and you're going to be happy. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so here's the story. Y'all know that for the last several years, since the Supreme Court decided on Serpa versus Bruin in 2022, the anti-gun movement and anti-gun judges across this great country have been pretending or actually engaged in an act of ignorance, saying, oh, we don't understand Bruin. It's so hard and complicated for lawyers to apply old laws, I don't know, like the Constitution, and to figure out how to do legal work and draw analogies and whatnot. What's been occurring, of course, is the anti-gun movement in the universities, in the press, in the lower courts, the law schools, are all pretending to, or actually act confused about how you apply originalism, how you apply the text of the Second Amendment, how you apply the historical tradition of firearms regulation, if there are any, to resolve Second Amendment disputes. And they're basically saying, we don't get it. We're not smart enough to understand it. It's so hard. So hard. Now, of course, the reason why they're doing this is because they want the Bruin methodology to fail for many reasons. Number one is they feel if the Bruin methodology is too favorable to the right to keep and bear arms, and if it fails, it will improve the chances of modern-day gun control laws being upheld by courts. Also, there's the grander plan that if you take out Bruin, you take out the whole notion of originalism, which is you look at laws when they are written and trying to understand the original meaning of the Constitution in 1791, not what some 21st century liberal law professor wants the Constitution to mean today, but what it actually meant at the time it was adopted. If you cannot make originalism work with the Second Amendment, where you do not have decades and decades of nonsensical liberal judicial activist precedent as barnacles on American jurisprudence to deal with, well, if you can't make it work in the Second Amendment space where there's none of those barnacles to speak of, then you really can't make originalism work as a legal theory anywhere in the real world, in the court system or beyond. And of course, by attacking the Bruin decision, not only are you attacking the Supreme Court's credibility and its ability to do its job, you're also attacking the Second Amendment. And last but not least, we know that the anti-gunners are desperate to bring back judge empowering interest balancing tests so they can always say, well, even if this violates the Second Amendment, the reality is when we balance the good and the bad and the guns and the public safety concerns, we get to take away your rights, we get to oppress you, we get to restrict your rights and liberties when it comes to the right to keep and bear arms. So they want to bring back interest balancing or tiers of scrutiny, which the Supreme Court has repeatedly rejected, including in Bruin and in Heller and beyond, in the context of deciding Second Amendment cases. Now, that gets to this very good news dealing with this Planned Parenthood case, Medina versus Planned Parenthood. And the reason why this is good news, and you'll see why in a second, is there's an old saying many of my friends have used, that when God wants to punish you, he grants you your wish, or be careful what you wish for. So you have this sort of gestalt or this kind of ongoing theme of like, oh, Second Amendment jurisprudence, it's so hard, we're not that smart, we're not historians, oh my God, so tough. Text is so hard to understand linguistically, history's so hard to understand, they're so confusing, how could we ever figure this out as mere lawyers from NYU law or Harvard law or whatever it is? Well, of course, what they're really doing is they're saying we need more clarification and guidance from Big Daddy, the Supreme Court, because we're not smart enough to figure it out on our own. That's what many of these lower court judges are saying, as well as their handmaidens in the media and their handmaidens in the law schools and the academy. Well, it's kind of amusing because that is a game that just got played in many respects in the context of this Medina versus Planned Parenthood case. Now, what is that case about and how does this tie into the Second Amendment? I'm going to show you. And remember, we do this on this channel to connect these dots that are not obvious to most people because I want to make you smarter than most people so you can go into a room with any law professor from an elite school and you can kick their butt when it comes to Second Amendment analysis, regardless of your background, as long as you learn from the Four Boxes Diner channel. I'll make you smarter and better than they are when it comes to our right to keep and bear arms. So with that said, if you look at the Supreme Court decision that just got decided in Medina versus Planned Parenthood, the technical question in the Medina case is, what is this particular language referring to any qualified and willing provider? Because what happened there was several states, including the state of South Carolina, had said that we're going to cut off state funding through the Medicaid program. We're not going to allow Medicaid funding to go to Planned Parenthood because they provide abortion. And even if someone wants to go to Planned Parenthood, this particular Planned Parenthood location or this entity in South Carolina, to get services other than to get an abortion, we, under South Carolina law or under federal Medicaid law, we can dictate that no federal money can go to Planned Parenthood in South Carolina that will fund them in any respect because they provide abortions. Because by giving them money to fund other parts of their operation, even if it's not specific to abortion, you're effectively indirectly subsidizing their operations, which means you're in effect subsidizing abortions. So the state of South Carolina cut off Medicaid funding to Planned Parenthood in South Carolina on the grounds that no amount of money should be allowed to go there. Well, Planned Parenthood sued along with patients or people that wanted to be patients, claiming that under the relevant statute, the phrase any qualified and willing provider allows them to be able to go to a Planned Parenthood and have that paid for by Medicaid. Specifically, here is what the case was about. The Supreme Court delivered a backdoor blow to Planned Parenthood, ruling that states may cut off Medicaid reimbursements for the organization's non-abortion medical services. At issue was a provision of the federal Medicaid law that guarantees Medicaid patients the ability to choose their doctors, or in the words of the statute, they are entitled to any qualified and willing provider. South Carolina, however, maintained that it could disqualify Medicaid providers for any reason the state law allows. So again, what's happening here is there is patients that were on Medicaid. They wanted to go to Planned Parenthood to use them for non-abortion services, and they were said, you can't go there and get it paid for by Medicaid because the state of South Carolina doesn't want money to go to Planned Parenthood because that will effectively subsidize abortions. And South Carolina made a decision that they don't want to do that. Now, the reason why this ties into the Second Amendment issue today, and it's going to make you happy, is, as you know, in the Second Amendment context, there's all this supposed confusion about how to apply Bruin and how to interpret the Second Amendment in the context of litigations. Well, it turns out that same game was essentially getting played where lower courts were expressing confusion about that language in that Medicaid statute, and specifically as to whether or not under that statute, individual patients and individual medical providers like Planned Parenthood, did they have a private right to sue the state of South Carolina under Medicaid? Did they have the right to sue in the first instance? And the courts were like, we're confused about all this. And by the way, you know that Judge Harvey Wilkinson, who we don't like on this channel as a judge, because he's terrible on the Second Amendment, among other things. Well, Judge Wilkinson, a tremendous disappointment to the conservative movement in 7 Ways to Sunday, he actually ruled against the state of South Carolina in favor of Planned Parenthood. And of course, needless to say, the U.S. Supreme Court has just reversed him big time. Now, this ties in the Second Amendment because, again, just in the Second Amendment context, there's supposed confusion about the Second Amendment. Here you have confusion about whether or not there's a private right to action. And the Supreme Court took note of that in explaining why they decided to take this case, hear this case, and rule on this case, of course, overruling Judge Harvey Wilkinson and the U.S. Court of Appeals for the Fourth Circuit and ruling in favor of South Carolina against Planned Parenthood. Again, the supposed confusion actually triggered the Supreme Court to step up and decide the case big time. And boy, was it a terrible loss for the left. In a 6-3 ruling, which included Amy Coney Barrett along with Clarence Thomas and Sam Alito all together, knocking out this claim that there was a private right of action for individuals to sue under the Medicaid statute, which was very, very unhappy. This really made the left very unhappy. But here's what the Supreme Court had to say about why they took this case. And tell me if you think this might signal some positive news coming up for our Second Amendment rights very soon. The Supreme Court wrote, quote, "The Court of Appeals reaffirmed its earlier decision, and once more, Judge Richardson wrote separately. Even after Televsky, he said, lower courts continued," listen carefully, folks, "lower courts continued to lack the guidance they need from the Supreme Court to determine when a federal spending power statute creates a right that private parties can enforce under Section 1983. Other circuit judges have expressed similar concerns, with a list of other judges, Judge Hamilton, Judge Livingston, and so on. Then it goes on, the Supreme Court, to say, in response to the Fourth Circuit's latest decision, the state of South Carolina filed another petition for cert. In it, South Carolina noted that other lower courts have disagreed with the Fourth Circuit regarding whether the section confers an individual enforceable right. And then it goes on to say, we agree, therefore, to hear this case. And the Supreme Court then, listen carefully, they said, quote, to resolve the circuit's disagreement and to address our lower court colleagues' calls for clarification, we begin by outlining how to determine whether a statute confers an individually enforceable right under Section 1983. Uh-oh, spaghetti-o. All that supposed confusion in the lower courts, right? I'm so confused. Whoa, this is so hard. All that gave rise to the Supreme Court saying, fine, if you lower courts can't figure this out and you're confused and you need guidance from Big Daddy, the Supreme Court, well, so be it. We're going to give it to you. We're going to give it to you. That's exactly what happened here. So the Supreme Court grants cert, and bang, 6-3, major, terrible loss for Planned Parenthood and the abortion rights movement in America, the left-wing components of all that. Terrible loss for them, 6-3, because of the supposed confusion of the lower courts. Now, the reason why I find this kind of interesting for the Second Amendment is because, again, we know that a big part of the plan of the left in America, the anti-gunners, is to, again, create this impression that the lower courts are not capable of figuring out how to apply Bruin, which is totally hooey for the reasons I've written about and for the different articulations that many good judges, including Supreme Court justices, have pointed out. But just to show you just how crazy some of this stuff is, let's just check out one recent article that kind of summarizes up quite nicely in The Trace that did a pretty good job on this article, at least laying it all out, demonstrating why the U.S. Supreme Court is going to take more Second Amendment cases, and it ain't going to go well for the anti-gunners. But let's just check out what The Trace had to say in discussing this supposed confusion among academics and lawyers and courts, supposedly in applying the Second Amendment. So to begin, The Trace starts off their entire article with talking about confusion. Here's what it writes. A 2022 Supreme Court decision that gun laws should align with the nation's history and tradition has sown confusion in courtrooms and weakened long-standing limits on firearms. Then it goes on to say that, as we continue forward, quote, a trace analysis of more than 2,000 challenges to gun laws since Bruin found that a case's outcome now hinges on conflicting interpretations of America's complex and often uncomfortable past. As judges, lawyers, and historians argue over what history counts and what it means, gun right groups have capitalized on the confusion with sweeping consequences for public safety. And then, of course, this article goes on to say, again, it's still confusing. Here's what they write next. Quote, many judges have openly admitted they're not equipped to evaluate whether centuries-old statutes match modern-day restrictions. Eric Siegel, a constitutional law professor, said judges lack expertise. The judges' lack of expertise is evident in their rulings. He says there are 1,000 decisions going in all directions because history is not reliable in the hands of qualified historians, much less in the hands of unqualified historians. And he goes on to say, none of them should be doing history in any meaningful sense of the word. So again, what you have here is it's too hard. Now, this is a bunch of hooey for reasons we've covered in prior videos. We could do it again. But the bottom line is this. The left and the anti-gun movement, the people don't like Bruen and don't like the Second Amendment, and want to bring back tiers of scrutiny and judge-empowering interest balancing test. They are all teaming up together to claim that there's confusion and a misunderstanding, and it's Bruen's methodology of text first, history second is too hard. That's nonsense, but that's not the point of this video. The point of this video is this. As the people involved in the Planned Parenthood case of Medina versus Planned Parenthood, South Carolina, the other litigants and so on learned, claiming in the lower courts that there's confusion and they need guidance from the Supreme Court may be really cool and sound neat in the press and the mainstream media. Might give rise to some column inches for people that have to blog for a living. Might get you tenure. Might get you published in a law review. Might get you quoted on CNN. That's fine. No big deal. That's okay. But the reality is, as the Supreme Court showed, that if you complain too much and say you really don't get what's going on and you need help, the outcome is going to be that the U.S. Supreme Court will take those cases and they will decide those issues. And if you're in the left in America, it may not be what you like. And I suspect when it comes to our Second Amendment right to keep and bear arms, this questions and issues of feigned and otherwise sold confusion is not going to end well for the anti-gunners in America. Now, it may take some time, it may take a couple years, because the legal process is slow, especially at the Supreme Court level. But in the end, as we saw in the Medina case, in that great quote I just gave you from the Supreme Court, watch out. Be careful what you wish for. And asking for guidance from the Supreme Court is not going to cause the Supreme Court to reject Bruen. They're not going to do that. That ain't going to happen. They're going to clarify Bruen. And when they do so, I suspect the anti-gunners are not going to like it any more than today. The supporters of Planned Parenthood are not particularly happy with the clarification that we just saw by the U.S. Supreme Court overturning the decision by Fourth Circuit Judge Harvey Wilkinson, which said basically you cannot sue the state of South Carolina to get money to pay for your non-abortion providers or your non-abortion services if you want to go and frequent a Planned Parenthood in South Carolina. That's a no-go zone now in terms of how the funding works. And I think that sort of similar answer that will make the left unhappy would occur and arise in the context of the Second Amendment if the anti-gunners continue to push the theory and the argument that Bruen is too complicated to apply. Okay, so there you have it, folks. Hope you enjoyed connecting the dots here today with these Supreme Court cases. A lot more to cover in the next several days. Make sure you check me out on Fox News over this weekend. I think I'm going to be on Saturday sometime in the afternoon. I haven't nailed down my schedule, but I suspect you'll see me on Fox News covering the Supreme Court stuff this weekend. And again, I thank you for tuning in. Make sure you follow me on X @4boxesdiner. Don't forget to subscribe both to YouTube and to Rumble, and I'll talk to you real soon, I hope, here at the 4 Boxes Diner.
Orders up. Table 2A.